Good evening and welcome again to the Defense Chronicles. This is Bocobo. Tonight we have with us, once again, Senator Francisco Tatad. Good evening, Senator Tatad.
Good evening, Leslie.
Let me go direct to the point. Your column dated May 16, 2012, today, entitled Recusing Angara. And I quote you on your column. It says, recusal, based on Black's Law Dictionary, is a process by which a judge is disqualified on objection of either party or disqualifies himself or herself from hearing a lawsuit because of self-interest, bias, or prejudice. My question is, the defense panel did not ask the Senate impeachment course to recuse Angara, but it asked Angara himself to recuse himself.
Yes, this was the situation then, and is still the situation obtaining now. I suppose any party to a case like this has the choice of addressing the recusal request to the court itself or to the party involved.
Yeah.
Obviously, the defense thought that on his own, Senator Judge Angara would be able to judge for himself whether he should recuse on the basis of the grounds presented in the motion.
Now, on your column, Senator, you said, under the Code of Judicial Conduct, a judge should be able to inhibit himself if he is found to be related by consanguinity or affinity to a party litigant within the 6th degree, or to counsel within the 4th degree, or who knows his or her spouse or child has a financial interest as heir, creditor, fiduciary, or otherwise in the subject matter, in controversy, or in any party to the proceeding, or any other interest that could be substantially affected by the outcome of the proceeding. Has there been any reaction from Senator Angara's son, his namesake?
I'm not aware of anything that his son has said to the public or to the press.
Yes.
But Senator Angara himself stood on the floor of the Senate to say that there's no conflict of interest, there's no reason for him to inhibit. His argument is that his sitting as judge in the impeachment court is by virtue of a provision of the Constitution, which names the senators as senator judge.
Yes.
And his son, on the other hand, is a spokesman for the prosecution on the basis of the decision made by his peers. He was elected to the position, apparently. Now, we're not disputing the veracity of this statement, but even if true, I mean, it is no argument, because it does not take care of the ethical issue involved.
Yes.
I mean, there is a real conflict of interest, because Sonny Angara is interested in the conviction of the Chief Justice.
Yes.
He is said to be eyeing a seat in the Senate next year as a candidate of the ruling party, the administration. And the administration is openly campaigning for the conviction of Corona. Now, under those circumstances, would the father, Senator Angara, who would presumably like to see his son get elected as senator, do anything to ruin his son's chances of running or possibly winning as senator?
Yes. Now, in your column, Senator, you mentioned that Angara pointed out, and correctly so, that such rule is not in the rules of the Senate impeachment court.
No, it is not.
And you said that the point here really, as you mentioned, just recently is, it is not more of a legal point, but more on ethics.
Yes. It's being too technical, but you see, when we talk of conflict of interest, we are talking really not simply of the legal issue, but the morality or the ethics of the issue.
But doesn't the senator sit as a senator judge in obedience to the Constitution?
Yes, yes, but the Constitution does not preclude considerations of ethics.
So his son should have been the one to...
Ethics is the beginning of it all.
I agree, Senator.
Now, since there's no way of preventing Senator Angara from sitting as a judge, I mean, he could have told his son, or his son could have, on his own volition, told his colleagues in the House, hindi ako pwede kasi yung tatay ko judge.
Yes.
Napakalinaw. But that did not happen, so we have this situation.
So, if the move could not have come from the senator, it should have come from the son to say, I inhibit myself. Yes. Apparently...
That would have made him worthy of the Senate.
Yes, that's right. After all, he is in fact running for the Senate.
He wants to become a senator.
Yes. You said also, Senator, that the judge must not only be seen as neutral, but above all shine, and I repeat the word shine, in that neutrality.
Yes.
I remember in the olden days, Senator, and I know this for a fact, members of the court...
You're too young to remember the olden days.
Well, I remember my grandfather,
Senator,
as one of the associate justices of the Supreme Court. He would not attend parties and social gatherings for the reason that he might meet somebody whose case is being handled by the Supreme Court, and he would be put into a compromising situation.
Yes.
That should actually be the same. It is very
Well,
dangerous.
that virtue is lost, and I'm suggesting that we try to revive it, and the father and son
has a very much chance to
have the opportunity to show us.
You also said, Senator, in your column, although he says he remains unbiased and neutral, what does the public say he is? Again, it really depends on what the public says, especially now that he did not inhibit himself, or the term is
I'm trying to say, Leslie,
yes,
that he can profess complete impartiality, objectivity, lack of bias, and he may even be really impartial and without bias. But that is not the point. The point is, as I said, he must shine in his neutrality and impartiality on the basis of the objective facts, and the objective fact about his son cannot be denied. It's the source of worry for
So an act of statesmanship still awaits him? It's not too late.
He has the opportunity to provide that act of statement. And for his sake, as an old politician who is about to finish his long service in the Senate, for the sake of his son who wants to become a senator, I think we should take this opportunity to provide this example, this firm gesture.
But a few days ago, Senator Tatad, he did take the stand and reacted on calls for him to inhibit. And in fact, he did mention his grandson. What is your reaction?
Well, this is precisely why I wrote the piece, because for me, the statement was unsatisfactory. I mean, it did not really discuss the real issue. He should have discussed.
Senator Tatad, yesterday we had no less than the Ombudsman of the Republic, Ombudsman Conchitina
Carpio Morales.
And What is your reaction on this? A lot of people now on Facebook and Twitter have found her to be quite arrogant in the way she was answering questions. In fact, a lot of people are disappointed and saddened by this show of arrogance and pride.
No, I will not dwell into her manners.
Okay.
I think the bigger issue is there. It has to do with the constitutionality, legality of the entire thing.
Yes.
One lawyer said this is good theater, but very bad law. And she said this before Morales appeared before the Senate, and that's exactly how it has turned out to be so far. Well, she was received with deference by the court.
Yes.
And she tried, I believe, to match that deference with respect to the Senate presiding officer. But she tended to be patronizing when she spoke to Justice Cuevas.
Yes.
Her former Supreme Court colleague and lead counsel for the defense. Now it took Senator Judge Miriam Defensor Santiago to put some of the more important legal questions affecting governing data files.
Yes.
Now I have asked the same and many more questions even before that. What are these questions? Well, first of all, Corona is being tried by the Senate on the basis of an impeachment complaint filed, initiated by the House of Representatives, and this complaint contains an allegation similar to the complaint that Carpio Morales received from certain practice on February 17,
Yes.
meaning 1 month after the start of the trial. Okay?
Yes.
The Senate Impeachment Court has been trying to tell the public that it is autonomous and independent, that even the Supreme Court has any business trying to go over what goes on in the Senate impeachment.
No, Senator.
Yet you have the Ombudsman trying to investigate a complaint that is already being heard by the Senate.
That's right.
Is this within the ambit of her mandate? He says her mandate is to investigate all public officers. That is in the Constitution,
Yes.
and in the law.
Yes.
But
However,
there's still a distinction between impeachable officers and non-impeachable officers. What is the meaning of this distinction? By impeachable officers, we mean the provision in the Constitution which says that the President, Vice President, members of the Supreme Court, members of the Constitutional Commission, and the Ombudsman may only be removed on conviction in an impeachment act. And outside of an impeachment trial, you cannot charge any of these officers of a criminal case while they are in office. As for all the others, they're open to investigation. So, is Morales saying now that she can investigate any or every impeachable officer on the basis of a complaint that comes to her, citing an alleged wrongdoing that is already being heard in an impeachment trial. Even before that, assuming there is yet an impeachment, is she saying that she can investigate every impeachable officer, which includes herself?
That's right.
Can she investigate the president? This is the first impeachable officer. Will she? Can she investigate herself? Or will she investigate herself?
That's right. Now, again, right after she appeared, there have been renewed calls for the Chief Justice to resign. Apparently, Senator Tatad, is there a pattern here? Because under the anti-graft law, a person being impeached is not allowed to resign from office. But going back a few years ago, isn't that what they did to former Ombudsman Mercedes Gutierrez? They forced her to resign.
No, you can see that
is there a pattern?
This is part of a big propaganda campaign. The objective is to get Corona out of the Supreme Court by whatever means. So, even the so-called survey questions. The question was, if he's acquitted, will he resign? You know, so it is all in there. But there's one important point that probably we should underline. The statements coming from Morales, one of the statements coming from Morales is that the investigation was being undertaken for the possible filing of an impeachment complaint next December. So what is the meaning of this? The meaning of this is that even the Ombudsman herself seems to be convinced that this case that's being tried now has no chances of, sending Corona out of the Supreme Court. That he cannot be convicted of on the basis of the charges that are being heard now.
She mentioned a future date.
So she is preparing for next. But that in itself is prohibited by law. Because under the Constitution, no person can be impeached twice, more than once in a year. And I think, and that has been reiterated by the Supreme Court in a ruling, I think, penned by Morales.
That's right. That's right.
So, may problema tayo talaga rin.
Let's go to the bank accounts, Senator. We were told that Chief Justice has $82 accounts. Now, I liken this to the 45 properties. Will we end up with just like $5 accounts? Is there again
I really don't know. I really don't know, because what was brought to the court was a pile of documents tending to show alleged banking transactions coming from AMLAC. AMLAC has no record of bank deposits. Just transactions. Assuming these are correct records, we'll have to still verify and confirm that the so-called records are correct. So it's too soon to be talking of how many bank accounts and what is the real meaning of this. This began in 2003. Up to in the space of 8 years, they were all zeroing on Corona. Masigasig, no? But I mean, until we get to hear from AMLAC, we get to hear from the banks, we'll never know. But the point is, the whole thing, the $10 million was not part of the complaint filed by the private practice on the basis of which the Ombudsman decided to investigate.
Yes.
Paano nakarating doon? And it's not part of the allegations in the articles of impeachment for which the Chief Justice being tried.
Yes.
So, is he now going to be judged guilty or not guilty on the basis of something other than what is before the court?
Yes.
Yun ang problema natin dito. That's right. I think the Ombudsman is right in presuming that walang conviction dito. Kaya maghanda na tayo for the next round.
Right. Very well said, Senator Tatad. Any last words before
no,
we
it's
go
too
to...
early for last words.
Okay. I mean,
we're watching. We continue to
Yes.
To watch, no? But I suppose the senator judges are having a tough time trying to decipher what has really happened to the court.
Before we finish this interview, Senator, and I have to ask this to you, a lot of people, their reaction yesterday when the Ombudsman was on the witness stand, they feel that she had instilled a considerable amount of fear among the other senators, because now she's saying, I can investigate you on a mere letter sent to me. And they're saying it was only Senator Miriam Defensor Santiago who had the guts to come up and meet her.
Well, yes, she has a chilling effect on everyone. Because she has shown that in spite of the fact that a certain allegation has already been tried, she could still make that as the basis of an investigation, even though the results of some of the investigation did not touch that particular allegation, but went somewhere else.
Okay. Senator, thank you very much. Till next time.
Maraming
salamat po.
Thank you.
Thank you for joining us once again with the Defense Chronicles with Senator Tatad. This is Leslie Bocobo.